big debate is a split verdict on the hijab issue. The debate between right to choose or regression will continue a bit longer. Just like Times Now told you today, the Supreme Court two-judge bench differed on whether Karnataka's hijab ban in classrooms should stay or go. In a split verdict, the judges agreed on a divergence of opinion and recommended that the Chief Justice of India set up a three-judge bench to decide on the ban.
So backing the ban, Justice Gupta, in the past too, who has said as far as hijab is concerned, it is not an essential practice, and pointed out that only one community has insisted on a religious dress code. However, the other judge, Justice Dhulia, contended that it is a matter of choice for the girl and the student, and that the aim should actually to make life better and its education better when it comes to a girl child.
So the split verdict, in fact, has further created a difference of opinion, a rift, so to say, in the society, and all eyes are now on the larger bench. We got your reactions from the Karnataka government also. Representatives of the government saying we are expecting a better judgment from the constitutional bench, and in fact, both sides are not looking at this particular verdict as a setback to them. The petitioners are looking forward to what the larger bench has to say in terms of the constitutional questions that now arise. Let's go across to Amita to try and understand what really was said by the two-judge bench.
So as far as Justice Gupta and Justice Dhulia is concerned, where there were already hints as far as even when the hearing was taking place that there might be a possibility of a split verdict, and that is exactly what has happened today. As far as Justice Gupta and what has happened in the court is concerned, because we are talking about 2 points of view here. As far as the government, Karnataka government to the Supreme Court, this was a 10-day long marathon hearing that was taking place, and one of the petitioners, their advocate Dushyant Dave, who was representing them in the Supreme Court. Now, Karnataka government side argument has been that hijab is not an integral or an intrinsic part to the religion of Islam. The counter was that outside authority can't say that it is not essential. So those were the arguments that were put forth. Now the counter to that was given by the Karnataka government in the court, that essential practice may not be integral. The counter was that court cannot stop women from wearing it. So as far as the right to choice or to right to practice their religion is concerned, that was one of the main matters that was being discussed at length. Now, the split verdict that has taken place as far as Justice Gupta is concerned, because he upheld the Karnataka High Court order that implemented a ban on the hijab in classrooms. As far as Justice Dhulia is concerned, he has gone on to say that it is ultimately a matter of choice of the girl, because he said it is up to the education, the right to education as well for the girl child, because they have to go through a lot when it comes to imparting basic education to the girl child and the girl students. Now, as far as Justice Gupta is concerned, he went on to say that there have been 11 main points and questions that had been raised and remarks that were made by Justice Gupta in this, as far as upholding what the Karnataka High Court ban is concerned. As far as today is concerned, the CJI will now be taking up the matter to refer it to a larger bench, but the status quo on the Karnataka High Court ban is concerned, that will remain till today, till the time the verdict, the next verdict from the Supreme Court comes out.
Right. Amita, let's also take a look at the reactions that we have so far.
Because we don't have the benefit of having read the judgments yet. Justice Gupta seems to have framed 11 questions of constitutional law that he felt arose in this case. He did not give the reasoning, and said that we have answered it against the appellants. That Justice Dhulia, on the other hand, said that he felt that this is not an issue of essentiality, and the High Court misguided itself by going into the question of essentiality of religion, and said this is actually a question of right to education of the girl child. This is a question of freedom of expression of the girl child. This is a question of right under Article 25(1). And not of essentiality. And he said that the question that he asked himself and that he has chosen to answer is, are we making the life of the girl child in India any easier? The appeals had to be allowed, and the judgment of the High Court and the order of the Karnataka High Court had to be set aside. The matter is still pending in the Supreme Court. We hope that an appropriate bench will be constituted at the earliest. Hope for an early resolution and justice.
Justice Dhulia has emphasized that the choice has been left to the lady. Whatever she wants to wear, she can wear. And the third thing which he has emphasized in this judgment is that he has emphasized on the education of the girl child. He has said how the girls in the villages and how the girls in the remote areas they work, they have to assist their families. then they have ultimately they go to the school. So it's very important for the girl child to have her education. So he has emphasized on the education of the girl. He has emphasized on her choice, and he has depended on the bejoined manual judgment, which has upheld this this practice where a lady can put whatever covering. I appeared. One of the petitioner was Charanjit Kaur, in which she was a Sikh lady. She was saying that when I have this choice, then other girls and other ladies and other ladies from the various communities, they should have all this choice also to cover their heads while they are going to schools or wherever or which place they are going to.
Justice Dhulia has differed with his view, and he has expressed that he has a differing view because a girl child faces a lot of problems while they are being sent to the schools and colleges, and their right to education is more important than wearing or not wearing a hijab. Operative part of the order says that it has to be placed before the Honorable Chief Justice of India, and he is going to form a new bench. Either it will be a larger bench or it could be even 3 judges bench. There is a divergent view between the 2 honorable judges, and therefore until the matter is referred to a larger bench or it is taken up by another bench, that